familiar faces out here. And my partner always starts off with a joke, so I feel like I have to keep the tradition going. So I have a couple Thanksgiving jokes. The first one is, why did the turkey bring a microphone to dinner? He was ready for a roast. What do you call a sad cranberry? A blueberry. And last one, what made the cranberry blush? It saw the turkey dressing. That one's pretty good. Okay, so I'm going to start talking about just cause terminations in San Diego County and City of San Diego. You're gonna have to bear with me because this area of law is very dry. It's a lot of information, and I'm gonna throw a lot of things at you. I will try to talk slowly. Please save your questions for the end, because I will save time to answer questions. And silence your phones. And silence your phones, please. All right, so we're going to talk about the differences and the similarities between California rent control and City of San Diego rent control. The exemptions to all rent control, because most of the City of San Diego exemptions also apply to the California exemptions. There's a lot of crossover there. And then if your property is not actually exempt from these rent control laws, we are going to talk about what is just cause for termination and how you can actually terminate those tenancies. All right, we can just keep going through. All right, so to be more specific about what I'm talking about, we are talking about the Tenant Protection Act of California from 2019, which became effective at the beginning of 2020. And the City of San Diego residential tenant protections, which did not become effective until last year and were amended from a previous tenant protections. To expand a little bit more on the state rent control, some of you might have heard of AB 1482. These are all the same thing. The Tenant Protection Act of 2019, AB 1482, or some people just call it California rent control, just cause, or rent caps. These terms are used very interchangeably. They all are talking about the California TPA, that Tenant Protection Act that created statewide rent control for all of California. One more note on that last slide is that it not only created just cause terminations, meaning that the tenant has to either do something wrong or you have to provide a reason to terminate, but it also provided rent caps for all of the state. So some of these properties that have local rent control that also apply to these properties, you are also still dealing with those rent caps from the overarching rent control from the state of California. So one big thing about the California TPA is that the rent caps start on day one of tenancy, whereas the just cause provisions of the California TPA don't start until the tenants have been in the property for 12 or more months. And this is important because the City of San Diego is very different. Moving on to the City of San Diego rent control, it's called the City of San Diego Residential Tenant Protections. As I was saying, this was put into place last year in June of 2023. Some of you might remember the Tenants' Right to Know ordinance that was enacted in 2004. It was entirely replaced by this new scheme that somewhat models what the state did, but there are some nuances, some differences that become very confusing very fast for a lot of our clients. This new SD residential tenant protections, it majorly expanded the just cause termination requirements, and it only applies to the City of San Diego proper. Some of our clients don't realize that this also applies to La Jolla and San Ysidro, because those are also considered cities of San Diego that have to comply with San Diego rent control specifically. One more thing is that the just cause provisions of San Diego rent control, they trump the California ones. So you don't have to comply with both if we're talking about City of San Diego properties. You would only have to comply with the just cause provisions of City of San Diego and not those of California. But the little caveat to that, to make your head spin, is that you would still have to comply with the rent cap provisions of the state rent control. And we'll keep talking about this a little more. All right. As I said before, the big difference between the just cause provisions of California and San Diego is that California starts at 12 months. City of San Diego starts from the first day of tenancy. So if you get a tenant in there in City of San Diego and you just don't really like this person, they're a pain, they keep asking for you to fix things, you cannot remove that tenant from your property unless you have cause to remove them. And that's from day one. So there's no just straight 60-day quits, there's no straight 30-day quits. Every single termination notice in City of San Diego has to have cause. I'm not going to spend too much time on this one. This slide is more for general information. We will post this on our website, so if you don't take a bunch of notes, it will still be on there. You'll be able to see it. These are just the main differences between the new scheme in the City of San Diego, which is the residential tenant protections, and the old scheme of tenants' right to know. I already mentioned that a lot of these provisions were beefed up for just cause. The protections moved from day one versus in the past, it was only after 2 years that the protections hit. And now there's relocation benefits involved in City of San Diego, which we didn't see before until the middle of last year. All right. I'm going to focus on some of the exemptions from state and local rent control. Most of them overlap. You will see references on these slides to both the state ordinance and to the local statute that applies to the civil code. So the first 3 exemptions probably don't apply to most properties. They're hotels and motels, short-term rentals, hospitals and care facilities, and dorms. Most of our clients don't come to us with these types of problems, sometimes the short-term rentals, but for the most part, those properties are automatically exempt. Exemptions 4 and 5. These are exemptions that our clients often have questions about because this is when our clients live on properties where the tenants live as well. This is where a landlord has a single family home and is renting out a bedroom. That property is automatically exempt because they share bathroom or kitchen facilities. This is where a landlord has a house with an ADU and an accessory dwelling unit. They live in the main house, rent out the other 2, or vice versa. Those properties are automatically exempt. And again, we are talking about they are exempt from state rent control, they are exempt from City of San Diego rent control. So these properties do not have to comply with just cause, and they do not have to comply with the rent caps. And the exemption from just cause is automatic without doing anything else. Exemptions 6 and 7, these are for duplexes. The duplexes are where the landlord has to live in the other unit as their principal place of residence from the beginning of the tenancy and throughout the tenancy to claim this exemption. If the landlord is not living there at the beginning or the landlord moves, you no longer have this exemption, and rent control applies to your property, just cause applies to the property. The next one is for new construction. Anything that has a certificate of occupancy less than 15 years, that is deemed exempt from rent control automatically without providing notice. Again, this is for both City of San Diego and for the state of California that these exemptions apply. Now, number 8 is where most of our clients get themselves in trouble, and this is what I'm going to spend the most amount of time on because this applies to single family homes and to condos. And in order to receive this exemption, it requires you to do something. Well, first you have to be the proper owner. You can't be a REIT, a real estate investment trust. You can't be a corporation. You can't be an LLC that has a corporate member. And you can't be management of a mobile home park, which doesn't usually apply to most of our clients. LLCs are okay, which tricks some people up. You just can't have any corporate members. So trusts are fine, owning property individually is fine, or owning property in an LLC is fine as well if you have multiple members. There's no problem to receive this exemption. That's the first element. The second element that you have to comply with is actually giving proper notice to receive this exemption. The notice should be included in the lease, and it is very specific statutory notice. This notice applies specifically to the California TPA. So this is an exemption notice that would be incorporated into the lease either as an addendum, as a change of terms, something the tenant signs off on, or actually provision of the lease. AOA has very good forms that includes these terms, but you have to have this particular term in your contract to be exempt from rent control for single family homes or condos. This is the notice of exemption from City of San Diego. It looks very similar to the State of California one. It is different. And if you do not have it in your lease, you are not exempt from San Diego rent control. A lot of our clients are not aware of this. AOA is aware of this, but a lot of our clients do not know for City of San Diego proper, you have to have this notice of exemption in your lease or else your property is not exempt for these. And why this is so important and why I'm harping on this is particularly for San Diego. In March, there were revisions done to the residential tenant protections by the San Diego City Council. When they added revisions, they added section 98.710, which is right here. What it says is basically if you are out of compliance with the City of San Diego residential tenant protection notice requirements or any other provision of that code section, any notice you serve is void. What does that mean? If you don't have an exemption notice in place, you can't serve a non-payment notice. If you don't have an exemption notice in place, you can't serve a tenant with a perform notice if they are causing all sorts of problems with their neighbors, if they're cussing, if they're throwing trash, if they're doing anything else. You cannot serve an enforceable notice and evict your tenant if you are out of compliance. The notice is void. It is a very steep penalty, one that most of our clients are becoming very quickly familiar with when they come to our office and we tell them we need to clean all of this up before you can do anything. And a lot of times we clean it up with a change in terms of tenancy notice, which is a 30-day notice. So you have to wait 30 days before you can do anything as far as enforcement goes with a tenant or termination. So you can't serve a termination notice or an enforcement notice. It's a very stiff penalty. All right. This is a very long exemption section that basically just says the exemption is for affordable housing. This does not include Section 8, and that's a common misconception. Section 8 is not affordable housing. Section 8 is fair market housing that a tenant receives a voucher to pay the landlord for that fair market housing. So it does not include Section 8 in exemption. So Section 8 tenancies are still subject to California rent control and City of San Diego rent control. There was confusion on this previously. A lot of people and a lot of attorneys thought it was the opposite. Since then, City of San Diego specifically stated in their ordinance that it does not include Section 8. There's no exemption. All right, so big takeaways. You only need one exemption. So all those exemptions up before number 8, if you qualify for those exemptions, you don't need to give any notice. You qualify for those exemptions. So for example, you are the landlord that lives on a property that you share an ADU with a tenant. You're automatically exempt. You don't have to give those notices that I talked about. You can sit happy knowing, okay, I'm in compliance without having to do anything else. So if you qualify for an exemption, you don't have to qualify for another, even though technically that is a single family home that otherwise would need notice if the landlord didn't live on the property. Another thing, if you fail to give notice, we can fix these issues most of the time, either through a change of terms notice or through an addendum. That change of terms notice that I spoke about a little earlier, it's a 30-day notice and change of terms of tenancy. It is a unilateral notice, meaning that you can serve it on the tenant to create new terms in your lease that they don't have to agree to. Because a lot of times when you come to me, it's not because the tenant is agreeing to sign something for you. It's because the tenant is not cooperating, you have a problem, and you need it fixed. So that change of terms notice we serve all the time to incorporate new terms into contracts unilaterally, regardless of whether or not the tenant agrees to it. And we can do that and incorporate these exemption notices, or what I'll talk about a little bit later is non-exemption notices. So we can fix some of these issues. If you're in a lease, it's a little harder. You would have to get an addendum signed by a tenant to fix some of these problems, or other workarounds. And then finally, I already discussed it, that City of San Diego penalty that requires compliance with the ordinance, and it literally says if you're in violation of any provision in that ordinance, that your notices are void. Doesn't matter which one, but if you're not giving a notice of exemption, or you're not giving the proper terms in your release to be in compliance, you are out of compliance, your notices are void. It is very harsh. All right, so everything we had talked about before was properties that are exempt from rent control. What is required to claim those exemptions so that you don't have to deal with just cause terminations. Just cause terminations only apply to properties that are either subject to state rent control, California rent control, or some form of local rent control. And right now we're talking about City of San Diego only, but any local rent control. There's Chula Vista has a separate one. I'm not talking about that today. That's somewhat similar, just because it would just add one more level of nuance to this discussion. But we're just talking about any property that has some form of just cause rent control. All right. So this is the provision that has to be required. It has to be in your lease, basically telling the tenant, hey tenant, rent caps apply to your property, just cause applies to your property. For your tenancy. And this is only for, it's for all of California, but it also applies to all of San Diego County. So any property that does not have a local ordinance, this one comes into play. San Diego's a little different because it has its own provisions. So like I said, in June of last year, San Diego decided to create its own notices. This is the notice that San Diego residential tenant protections apply. It does talk about Civil Code 1947.12. Those are the rent caps. It's saying, hey tenant, the rent caps still apply to your property. That part of the California law applies. But what also applies to you are these San Diego residential tenant protections specifically. And they are somewhat different than the state of California. And they are what you have to comply with for just cause. So you have to give this notice, and then you also have to provide your tenants with a tenant protection guide, and it's a booklet at the time that they start their tenancy. So again, if you don't do this, if you don't have the notice that the tenant protection, the residential tenant protections applies, plus the tenant protection guide, your notices that you serve are void. And you cannot serve a notice until you've done both of these things. All right, so now we're going to talk about some of the at-fault just causes. So we are assuming that we have given either, that we've given a proper notice that, hey tenant, these rules apply to your property, and now we're trying to terminate you. We've already given either the notice from California or the notice from City of San Diego plus that tenant protection guide. And these at-fault notices are when the tenant is doing something wrong. All right, these 1 through 6, these are your pretty bread and butter notices. Default in payment of rent, a breach of material term. This is different than what our seasoned landlords know as far as giving a 3-day perform and then being able to move forward on it. Under California and San Diego, you have to give 2 notices now. You have to give the tenant an opportunity to cure before you actually give a notice to quit. So you give that 3-day perform, you wait your 3 business days, the tenants are still doing the bad behavior that they were doing before, whether it's, leaving dog poop everywhere or harassing the neighbors or, leaving things in the common areas. They're still doing it, then you can issue a 3-day quit. And after that 3-day quit expires, you can actually file your eviction. This is true for both State of California and City of San Diego. The other at-faults are the common ones, the nuisance, the waste. For both California and City of San Diego, a refusal to execute a written extension or renewal of lease. That is one that trips up a lot of people because they don't realize that you cannot terminate a contract at the end of a term because you have to have just cause. So say you have a 1-year term lease in the City of San Diego. Oh, the term's coming up. My tenant should be moving out of the property. Not the case. You have to give cause to terminate. They do not have to move even though the term is over. The term ends, it either becomes a month-to-month or you offer them a renewal. If they refuse, then potentially you can terminate, but you have to jump through the hoops. You cannot just self-terminate a lease at the end of a term anymore. Finally, criminal activity by tenant on the property or the common areas, which, all right, and then go to the next one. Okay, so 7, criminal threat to landlord or agent. This one is a little new because City of San Diego also includes criminal threats to other tenants. That's helpful. We didn't used to have that specifically in the statutes. A lot of times it was just deemed illegal activity at the property, which we would get pushback from tenants' attorneys because what is considered illegal activity could be potentially pretty broad. Tenant attorneys are arguing that illegal activity is something that landlord is actually being, or that the tenant is actually being arrested for, convicted for, whereas here, criminal threats are enough. We've had a lot of landlords that have received restraining orders against tenants because the tenant is, threatening to shoot the property management company. We can issue notices for these things very specifically under these at-fault just causes. Moving on, assigning or subletting the premises is a big one. Refusal to enter after providing proper 24-hour notices. The using the premises for an unlawful purpose. Again, these are harder for us to enforce because unlawful purpose would usually mean that there has to be some form of police report. I need something more than just, hey, the landlord telling me, oh, my tenant is growing marijuana and selling marijuana out of the unit. Well, usually that's not enough. I usually need more than that. And then finally, the tenant failure to vacate after the tenant gave notice. That's probably the easiest way for us to remove somebody from a building because the tenant actually is just not complying with what they said they were going to do. All right. Okay, so we are continuing to talk about the just cause provisions this is specifically for California. The at-fault just cause notices are only 3-day, 60-day, or 90-day for cause notices. And why there's no 30-day is because these particular provisions don't hit, just cause isn't required until 12 months. And so if we go back to our old landlord rules that we used to all play by, a tenancy of less than 12 months only requires 30 days notice. Well, there's never any situation where you're going to have a just cause notice under California TPA where it's less than, when the tenancy is less than 12 months. So tenancy is less than 12 months, you can still give your 30-day quit. And that's something that the caveat that some of our clients don't understand. It's, hey, yes, the California TPA applies, hasn't been 12 months, you don't need just cause yet. The 90-day notice would be for Section 8, just to clarify that one. All right, so moving on. So for San Diego, it slipped. We have 30-day just cause notices now. And I spoke about that a little before. Because San Diego hits on the first day of tenancy, if you're trying to terminate a tenant right out of the gate, say they've been there for 3 months, they're just a real pain. They're not doing anything that is technically breaching the lease, but we all know that there's some tenants that just like to cause problems. You can't turn around and just serve them with a 30-day notice without giving them a cause. You have to give them one of those causes, either one of those causes we just talked about or one of the no-fault causes that I'm going to talk about in a second. A couple more things about City of San Diego in particular is that there's supposed to be a notice of commission for any termination notice. There's no commission established yet, as far as I know, right? Yeah. As soon as there is, you're supposed to upload the notice to their website. I haven't seen it yet. It's been over a year. We'll see if it ever happens. If it does, I'm sure you will be hearing from Jeff and from myself, but it hasn't happened yet. I touched on this before. This is for both California and for City of San Diego. Before you can terminate a tenancy for a material breach, you have to give them an option to perform first. So first give them that perform notice, they're still breaching, then you can give a subsequent 3-day quit. So 3-day perform plus 3-day quit before termination. All right, so we are gonna move into the no fault just causes. These are very, very complicated notices. It's very frustrating for me and for my clients that these notices have become so complicated that they do require the assistance of an attorney for the most part to do these notices because there are just so many moving parts and the statutes are hard to understand, and there's tiny nuances between the state of California, City of San Diego, City of Chula Vista, where all of these notices are just a little bit different and have different requirements, different relocation benefits in order to qualify to terminate these tenancies. So what I've been saying the whole time, the just cause provisions of San Diego start at day 1. So if we're issuing a 60-day notice for one of these no fault just causes, from day 1, you have to provide the types of notices that I'm going to be talking about right now. For California, this is after a year, so after 12 months. These no fault just causes, meaning the tenant did not do anything wrong, after a year, you have to provide those types of notices. There were recent revisions to both the California law and the City of San Diego law. These went into effect in March of this year. It created an entirely different scheme that we've never seen, that our clients have never seen, as far as being able to qualify for some of these no fault notices. The big one being the owner relative occupancy. So in the past, our clients used to give a 60-day quit. It would have a very straightforward provision in it that said, hey, my brother's moving into the property. That's why I'm terminating. Or not even that, a 60-day quit that said, for the intent of owner relative occupancy. That's all that was required. You didn't have to do anything else. That was it. Now you have to have a term in your lease that says you can terminate for that reason, and that's for both California and City of San Diego. There's limitations. The person who is actually moving into the property, whether it's your brother, your sister, a sibling, they can't already live at the apartment complex. So if they live there already, you can't move them into the person's unit. And there can't be another unit that is similar to the one that you're trying to move out. So you can't say, hey, this tenant's kind of a problem, I'm gonna move them into that unit, while I have a 2-bedroom that's the same, that's vacant over here. You have to move them into that vacant unit. You can't terminate that other tenancy because of it. Additionally, you have to give the name or name in relation, if it's not obvious, of the person who is moving in. So for example, if the owner of the property is a trust, you're going to have to disclose quite a bit of information because the trust might not necessarily say who the actual owner is of the property and who the relative is that is moving in. This is a very significant shift for a lot of our clients that don't want to disclose personal information. But unfortunately, in order to qualify for these notices, you have to provide some of this information. Additionally, there were never time frames on how long the owner or relative had to move into the property. Generally, we used to tell our clients 6 months or so. The statutes now say that the tenants have to move in, or the tenant or relative has to move in within 90 days of termination of the other tenant, and they have to live there for at least 12 consecutive months. So if at any point in time they either, one, don't move in 90 days, or two, move out early, you have to offer the property back to the original tenant that you relocated. You have to give them relocation benefits to move back in, anything in excess of what you've already paid them, and essentially give them an offer to move back in. It's a very stark shift from what the structure that we had in the past. There is one exception, and that's if the person who, your relative or the owner that was going to move into the unit dies, and that's about it. If they pass away before they move in or during the term that they are there, if they haven't met the 12-month mark of consecutive mark of being there, you do not have to offer the property back to the original tenant. Another question I get asked a lot by our clients is, hey, I'm gonna move my relative into the property. I don't really wanna charge them like the full amount of rent. What can I charge them? The statute specifically says that you have to charge the same amount that the prior tenant was being charged. Whether I think you could probably charge less to a relative that's moving in, probably, or discount it. But the statute's pretty specific on it needs to be the same rent. I think that the purpose of it was so that you didn't bring in somebody and jack the rent up. But the statutes are pretty specific in saying that it should be the exact same amount of rent. And then finally, these new statutory schemes, what they created was who actually qualifies as an owner to move back into the property. To qualify as an owner, you have to own at least 25% of the property if you own it with other people. If it's an LLC, you have to own a 25% membership unless all of the members of the LLC are also family members. And they can be the qualifying family members, the children, the grandchildren, the parents, but they have to all be qualifying family members in order to avoid the 25% interest. You can have a lesser 25% interest if everybody's family. Right. All right, the next one for both California and San Diego is withdraw the residential rental property. We have seen a few opinions that say that withdrawal for sale is not a reason, and landlords have been cracked down on for doing this, for actually withdrawing the unit, putting it up for sale, and that being the reason that they withdrew. We don't advise our clients to do that. We will not issue notices if we know that the intention of our client is to withdraw for sale. Next is complying with government agency. Most of our clients don't have to deal with this. We've had a couple buildings that have been emptied because City of San Diego code enforcement came down. They gave our client a civil penalty notice and order that required them to actually vacate the entire building. So we have had a few clients that we've had to deal with these particular situations on, and that would give cause to remove these tenants. One caveat is if it's deemed that the tenant is actually the one that caused all the violations, you don't have to pay them relocation benefits. I have never experienced a code enforcement officer who would actually come out and say that it was the tenant's fault for all of these violations. But it's possible. All right, so this is the big one that we get asked a lot of questions about. It is very complicated, and there are a lot of nuances. So the intent to demolish or substantially remodel. Demolish is not what we're going to be talking about. We're talking about substantial remodel because it's very specific. We have a lot of clients that come in and are like, oh, this building's old. It needs to be rehabbed, yada, yada, yada. We need more than that. We need a lot more than that because we need actual substantial modifications, structural replacement. The big ones are electrical, plumbing, mechanical systems. Our clients that replace, old electrical, a lot of times that will work, but there's another caveat that it has to displace the tenant for at least 30 days. So if you can do this work and the tenants can live there in a safe manner or not be displaced for a consecutive 30 days while this work is being completed, you don't qualify. So if when I have clients come in, I say, hey, meet with your contractor. Get me a real timeline on how long this is going to take and how long the tenant would have to be displaced from the unit in order to complete these repairs or these replacements and modifications. Because if it doesn't give rise to a tenant needing to be actually out of the unit for 30 days, you're not going to qualify and you're not going to be able to terminate. The next one, I'm not going to talk a lot about this, the abatement of hazardous material or lead-based paint, mold or asbestos. You can terminate for those reasons too. The requirements are a little lesser than substantial remodel, and I'll talk about that a little bit more. But usually those types of abatements don't take 30 days, and the abatement has to take 30 days. In mold, if it's a very bad situation, then maybe, but a lot of times lead-based paint or like asbestos does not take 30 days. So it's hard for landlords to qualify to use that reason to remove a tenant from a property. So I already touched on this a little bit. Substantial remodel doesn't mean cosmetic improvements. It cannot mean you're just replacing a kitchen. Tenant could stay is not going to be removed from a property for a consecutive 30 days just to replace a kitchen, or even potentially a bathroom if there's more than one bathroom in the property. So landlords need to be really careful when it comes to flipping units that don't actually meet that substantial remodel definition. And I'm not going to go through every one of these items, but basically I just want to show everybody that while the California TPA and the San Diego RTP are very, very similar in their definitions for what substantial remodel means and in the requirements and what you have to do in order to terminate a tenancy for substantial remodel, there are differences, and the differences are subtle, and the differences would cause you to lose a case if you actually serve one of these notices on your own. Like I said, these are very complicated, they're very complex. There is a lot of legal jargon in both the California TPA and the San Diego rent control laws that are very confusing and create different requirements for our clients. The big one for San Diego is if you apply for a permit, you have to post that permit on the property within 3 business days of application. And there's nothing in there that says you can cure that. So if you go about this process without going through the proper channels and understanding all the steps you have to take to qualify to actually terminate a tenant for these reasons, you can get yourself into trouble, and you won't realize it until you're at the end of an eviction and your notices are technically invalid because you didn't follow the proper steps. So I will say for both California and City of San Diego, if you're going to be issuing notices for substantial remodel, you're going to have to pull permits for those items, and you will, at the time that you serve those notices, provide a copy of those permits to your tenant with other various items. And one other big difference between the two is that City of San Diego makes you run through an entire list of items under penalty of perjury. So if you're not sure about what you're putting in these notices and it's under penalty of perjury, you can get yourself into trouble. So that's why I'm saying these notices are very complicated. There's a lot of moving parts. They can be done. We've done quite a few of them, but they just, unfortunately, the City of San Diego and the State of California have made these notices so difficult for our clients that we don't have very many people terminating for these reasons. All right, we already went through some of the notice requirements for the at-fault just cause. These are only for no faults where the tenant hasn't done anything wrong. They all have to have a description of the cause, whether it's substantial remodel or owner relative occupancy. You are also required to pay relocation benefits, and this is for both the State of California and for the City of San Diego. State of California can be a waiver of 1 month rent or a direct payment. If a owner decides to make a direct payment, it has to be made within 15 days of providing the notice. City of San Diego is a 2-month relocation benefit. or a 3-month if the tenant is disabled. Again, it can be through a payment or a waiver of rent. What a lot of people don't realize is that you can't actually do a waiver of rent for 3 months when you only have a 60-day notice. So usually it needs to come in the form of a direct payment, which a lot of landlords would not like to necessarily do because they don't want to be paying 3 months of rent to their tenants. The only saving grace to that is it's a check for check exchange where you pay the relocation benefit to tenant today, they have to keep paying you every month's rent while they're still in the property. So if they don't pay you rent for one of the months while they're still there, you can serve them with a 3-day and evict them. And potentially recoup those relocation benefits that you paid to them. Also, part of these notices is you have to advise the tenant of their right to receive an offer to renew. And most of these offers to renew are not at the rent that the tenant was at the time that you actually remove them from the property. Most of them would be at fair market value, but you do have to jump through the hoop of giving them notice that they have a right to receive an offer. And if they turn around and tell you, yeah, landlord, I'd like to receive an offer, you actually have to follow through and do it down the road. It just creates a lot of touch points for the clients of having to continue interactions with these tenants. And what we discussed before, City of San Diego, you're also supposed to give a notice to commission that doesn't exist. I'm not sure when it will exist, but I'm sure you will be hearing from me and Jeff if and when it does. Oops. Alrighty. I just threw these rent increase slides in here just for your benefit. I'm not going to go too far into rent increases other than what we were talking about earlier with the California rent control. The rent caps do apply to all of California properties that are not exempt. Right now, City of San Diego, the cap is 8.6%. And that is effective through July of 2024. So it runs from August 2024 to July of 2025 is how the rent increase caps work. So every year we get a new cap. So the current ones in all of San Diego County, City of San Diego is 8.6. Just one more little caveat. Even if there's no rent caps on properties, there is a price gouging rule out there. If there is a state of emergency in place, which we have seen a lot of in the last 4 years, you cannot raise rent more than 10% or else it's considered price gouging. It is a crime. A lot of our clients are not aware that this exists. So we try to tell everybody as much as we can, especially when we're at these types of presentations. And again, just echoing what I said before, the rent cap for San Diego is 8.6. And normally we have the QR code, but we couldn't figure out how to do it to get it to you all today, but it will be on our website by tomorrow. So if you want to jump on our website, there's cards in the back. You'll be able to pull a copy of this presentation, or if you contact someone from my office, we'd be happy to send it to you as well. I'm at 4:15. I wanted to reserve time for questions because I know that was a lot of information. I'll get you right here first.